Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Welcome back. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy afternoon. Happy Thursday. Podcast Thursday afternoon. Podcast tonight. Super excited about that.
Kick back, taking it easy.
We are minutes away from returning to the Ashley Benefield trial. Just got my email from...
I saw a chicken fight.
Just got my email from the Summit County Courts, finalizing everything for our media access for the upcoming hearings in the Corey Richardson's trial. So that's all a go. We're on board there. I will be there in person for those. It's gonna be exciting. I think we've got 2 of them, a total of 4 days. They'll be happening in August. So we're gonna get that all sorted out. Excited to go meet Danny on direct. She'll be there as well. All right, Red Pen. What do you need to send me? Well, before you do that, Red Pen, hold on, hold your thought. Krista first in chat this afternoon. Thank you very much.
Video of roaches fighting.
Mm-hmm.
I don't know who won.
Because he's the guy.
All right, we're going to turn the sounds down just a little bit.
When are we going to break for lunch?
We just had lunch. Hedgehog in Space. We just had lunch.
Scratch all that. Oh, that was terrible. I apologize.
Yes, it was terrible. All right, sound's going down just a little bit here so we can talk.
I think I'm about to catch a whooping.
I'm about to catch a whooping. I probably am. That's probably the best sound effect we've heard in court in quite a while. So I'm super excited to have that one. All right. Let's see. Let's turn this one on here. Where's my mouse? Cannot see it from across the room. There we go. All right. Where are we? We're headed back down to Florida. Can we get a continuance with the Corey Richardson's trial after the Olympics, please? Oh man, if only court worked around our schedules, Mike. If only, that would be so much better. Let's see. Selena Carr upgraded her membership to jury. Selena, congratulations. Thank you very much. I'm going to be out in your neck of the woods here next month, so super excited. Greeners says, I emailed you a Boon PDF with a few more details about prison break investigations role. Thank you, Greeners. I read that over lunch. I appreciate the email. I got a couple documents which I want to talk about, and one of them is spicy. Let's see. Sarah Boon, prison break investigations.
This is not Burger King. People do not get to have it their way.
Prison break investigations is being used to facilitate Sarah Boon getting access to her discovery, because I guess she doesn't have all the boxes with her. So Prison Break is going to scan them all in, digitize all those boxes, which takes some time and money. The state is paying for it. Prison Break won't have any out-of-pocket expenses for that. But Prison Break will digitize it, put on however many jump drives it needs to be on. Then there's a hearing. That's what the next hearing is coming up in about a week. At that hearing, they'll bring those thumb drives. Those thumb drives will be transferred over to the jail, and the court is going to provide a digital method for her to access those. It's a mess. It's a mess, but that's how Sarah Boon is getting her discovery. So apparently she still does not have a discovery at her, readily accessible. That's what the update is with Sarah Boon. So Prison Break is actually doing some good for her in getting her to discovery. Will you update who Ted is from this morning? Ted, from our little TED Talk. We had a TED Talk with a jury. Ted was one of the jurors who one of his fellow jurors outed his name in open court. We know him as Ted. He was one of the 2 male jurors sitting on the panel. I think we've got a total of 9, 7 women, 2 men. Ted went to lunch yesterday and went to an establishment that was also happened to be where Jules went for lunch. But when he got there, the TV was on. It was playing news of the court proceedings, and people were having discussions about the court proceedings there. He says he didn't hear the discussion. He said he didn't watch the news. Jules said he asked for the TV to be turned off. And then at some point, Jules indicated that somebody at the restaurant was possibly saying something not complimentary about the juror for having asked for the TV to be turned off. That's all we know. We found out about this through an anonymous reporter who contacted the court directly, and the judge said, yeah, come on and testify in court. They didn't show up. Instead, they went to a law firm. The law firm contacted the court for the anonymous reporter saying, this is what we observed the other day. And then the judge, after hearing this and the sides heard about it, they pulled in all the jurors one at a time and asked them, which one is it? One of the women outed Ted. Ted came in. He said, yes, it was me. This is what happened. It was a nothing burger. Ted's still on the jury as far as we know, not being released. Nobody has yet. And we're just moving forward. So that's Ted. That's why we have Ted on the thumbnail. I missed a couple membership messages. Let me hurry and get these here. Let's see, at the very top, I think we have Jessica M. Welcome to the gallery. Thank you very much. Christine E. Welcome to the gallery. Brand new member. Christine, welcome. It's like Hotel California, though. You can never leave. So you're here now. Selena, upgraded membership to jury to get that padded seat. It's going to be wonderful. Comfortable as all get out. Kathy Mazak, a member for 11 months, says, almost my birthday. I can't wait to sing to you, Kathy. We're excited about that. Mildred Hornblower, welcome to the gallery. That's month 2 there on that light blue courthouse. Congratulations. You're well on your way to having a full collection of courthouse colors next to your name. Fairchair, member for 15 months as time flies. All the love. Thank you, Fairchair. Wouldn't be the same here without you. Appreciate that. Created by EJF, member for 9 months, says, thanks for covering this trial with an open mind. I'll tell you, I have not reached a conclusion. I don't know. I could not decide right here, in favor of the state. That's what I'm saying. If I haven't reached a conclusion, she's still not guilty. But I haven't reached a point where I could convict at this point. All right. A couple other things. I got another letter. I got another document. We talked about this. We heard a rumor from the Maya trial that Nick Whitney was off the case. We love Nick. Nick was amazing working with Mr. Anderson and his team. Did an incredible job, a key player in the case, and he filed to be removed from the case. And he spilled the beans. And there was a disagreement. I haven't read a ton into what the disagreement was, but it goes something like this. If I can pull it up for you. Let's see. I think it's this one here. And who do I give credit to on this one? Just one second. Renee, I think you're the one who sent me this. Motion to withdraw as counsel. Hang on one second. Kids are opening and closing the door. Okay. All right. Motion to withdraw as counsel. This is from Nick Whitney to the court, Judge Carroll. Pursuant to Florida Judicial Administration 2.501 F1, the undersigned attorney, Nicholas P. Whitney, hereby moves this court to withdraw as counsel for the plaintiffs Maya Kowalski, individually, Jack Kowalski, individually, and Jack Kowalski as personal representative of the estate of Beata Kowalski. The undersigned moves to withdraw based upon good cause. On July 9th, 2024, I raised concerns with Mr. Anderson over his refusal to provide a closing statement, his failure to notify our appellate and referring counsel in this case of the receipt of settlement and financing proceeds, and his failure to reconcile the Kowalski's previous cost advances against funds received. In response, on July 10th, Mr. and Mrs. Anderson directed that my access to the firm's server and email be severed. And, hang on one second, got to make it big so I can read, and terminated me. Given the intense public interest in the case, plaintiff's last known address, telephone numbers, and email addresses are not disclosed herein, despite the stated requirements for withdrawal found within Rule 2.501 F1. Should the court require such information, the undersigned will supplement this motion with a confidential filing. Anderson Glenn LLP remains counsel of record, along with Buell, Elliott, Ferrier, and Faircloth PA. Accordingly, the undersigned requests that the court enter an order withdrawing Nicholas P. Whitney as attorney of record for the plaintiffs dated this 24th day of July, 2024. It was a disagreement. That is why Nick is gone. Sad. I can't read anything else. I don't know the details, but he's out. That's what happened. So I will tell you this: Nick is an incredibly smart, brilliant attorney, and wherever he goes next, he's going to land on his feet. But it has things in there like settlement, big words like settlement. Was there a settlement reached? Did they pay out? Is this over? I don't know. I don't understand exactly the details of what he's talking about. If this is in relation to, I mean, clearly it's about the Maya case, but is it over? Is it over? I mean, can we turn off the counter? I don't think it's over yet. Anyway, let's go ahead and jump back. We are about to return to court in about 2 minutes. Take a quick peek at, let's see, I need my downstream keyer. Update the image. There we go. We're up at 133 objections. Very, very quiet day objection-wise. Anderson filed a motion saying he left without notice to another firm. Whitney was setting the record straight, and he spilled the beans. I don't know if Jules has any more information. I have not talked to the Andersons or Nick in quite a while. I will tell you this: they're amazing people. They really are. Getting to meet them and the family, the Kowalskis, and some of the people associated with that case, Dr. Joe. It's been incredible. It's an incredible thing. The story, yes, it's huge. It will forever be talked about. It's sad that things like this happen, but that's where it's at. We talked about it, and that's where we're at. So Nick Whitney left. He's the young guy, the younger of the two on the prosecution side. All right, let's see. We have. Let's see where we were supposed to be. That's probably the bigger story today. We were supposed to be in the defense's case right now. We were supposed to be hearing defense witnesses and testimony, but no. Instead, the state, I think, has more witnesses to call. We still have Brian Keelis on the stand, who was the guy who did the Cellbrite data dump on the phone. Hey, Mrs. R.A. Ooh, thank you. All right. Regarding my notice of settlement would have had to have been filed with the court. Yeah, I don't understand what's happening. The words he's using not making sense with where I understand the case to be. So that's where that. Jules is in court today. Yes. We've had some trouble connecting with her a little bit after lunch. I think she ran into somebody she knew, and she said, "I've got to go," and she was really excited. So we'll see if we can catch up with her later. I know she's filling in some other content creators as well on this same case, so excited for her doing that. Donna Burrows, welcome to the gallery, brand new member. Nana Cakes, I love the profile picture. Welcome, it's good to have you here. Thank you for your support. All right, let's see. Wait, I just caught up. The Maya lawyers thing is crazy. What's going on? We loved Whitney. We love them both. Absolutely amazing. The Andersons, both husband and wife. Talked with both of them, met them. We've had the Anderson sisters. We had them on the show here. We brought them on. They were sort of the behind-the-scenes people of the case. I've met both Nick and Greg when I went down and met with the family during the last the hearing we aired. Lots going on. So it's a lot of things. I don't think that changes anything about the case, but there was just a disagreement. There's a disagreement, and it was big enough that they said, yeah, probably should go our separate ways. All right. Michael Rogers says, hi, Recovery Addict. Been here since this morning. Looking forward to this afternoon. Thank you. I am too. I'm waiting for a little more testimony. I'm expecting the medical examiner. Are we not going to get that? We've had very, very little information. We had like a crime scene tech that took pictures of the trajectory of bullets through walls. That's the closest thing we had. I think the ME testimony is going to be huge if we get it. Mama of three, I've heard the same thing. I've heard that her daughter is not one. There just happens to be a young girl out there. I don't think it's actually Ashley Benefield's daughter that's in the protest. We heard that, I think, from Jules. So I don't know. I could be wrong. Let's see. Ivy Berlin says, help me. I think I'm developing a new addiction. Got a brand new steam cleaner. Oh, there's our defendant right there. Steam cleaner. And now can't stop steaming things. Might mop the whole city. Ivy, I'll just have to give you my address and we'll worry about your addiction after you finish cleaning my house. Is that okay? Oh, man. Jules is there in court. We see her there seated directly behind, 2 rows back behind Ashley Benefield. State said from the beginning that Emmy would be their last witness. Yes, that was a peek through the window into the media room. Let's see. She was out there with the grandma. Oh, she was there? That could be a problem. If she was out there with the grandma's been ordered not to talk to anybody about the case, and if she's out there picketing and protesting.
All right, good afternoon, everyone. We're back on the record in State versus Ashley Benefield. We finished the lunch break, and before we bring Deputy Keyless or Detective Keyless back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Keyless on Defendant's Exhibit 3, which I will describe as, and it's been told to me that these are from Ashley Benefield's phone, and the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016, and the page numbers are not sequential. That is, it's page numbers 1, 786, 222, I'm sorry, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly, State, I'm sure you have these as well, and may...
Well, I guess one of the issues, Judge, is that we aren't being showed anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB texts, but they're not all the same. They're some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over. May I approach? If you don't mind. Thank you.
You've raised a much more fundamental issue.
Serious issue.
There was no defendant's exhibit witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million
IA report, internal affairs reports from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the original witness lists were filed in the late June.
Ooh, this is a problem.
Probably would have liked to have addressed that
pre-trial,
well before trial. Could have also filed a motion to compel after the, the defense has 15 days.
So I can enlighten Your Honor.
All right, please.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump, DUMP. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, searching. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed. But at the deposition, I clearly presented these to Sergeant Keyless, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts? I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to this point where there are things being offered for evidence that have never been provided to the state, that I can't even find the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem we're having. And the obligations are different, as Your Honor knows, and I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not the same.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. the state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substantive statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump.
They provided a huge document.
Cellbrite.
Not just the
also,
extraction.
Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached to his deposition.
All right.
Judge, can I
Danny,
just clarify real quick?
I'm talking to the pool
defense did
media
not
right now
provide
about
us
Corey
a phone
Richardson.
number. We provided it to them. They listed it and said it's in our possession. So they did not provide us.
Okay, so she already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing, and that also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing.
That's sneaky because the defense won that.
We can just request that be done before we're in the middle of examining the witness.
And copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about. That being Defense Exhibit 3. And we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes. The court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes. Okay. So we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Miss Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum, use of discovery depositions as substantive evidence of criminal trial. I also had previously filed on July 10th of 2024 a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim, the Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So, I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting the hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Can I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Do you mind?
290 Southern 2nd, 73.
And I have one as well. I don't know if they want to hand it up now. I'll read it.
Seems like he's relitigating the self-defense hearing. It's some pretty good argument, other than the difference is the case he cited, the the victim caused the action, and he's saying the defendant's statement should be enough to qualify it and get it in, a specific act testimony. Listen to the waterfall sounds and the paper shuffling while the judge reviews this. This judge is not afraid to reverse a decision if he finds case law that supports it. He's done it once already. I will say this again. I love this judge more and more every single day. He is, even though I don't agree with everything he's done, he is a solid.
What you just handed out?
Yes.
Example of what we'd like in a.
All right, I've reviewed Henry.
A justice.
You want me to comment on Britain case that they just provided?
I haven't read it yet.
You just read all of Henry?
If you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So we don't have, I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overact, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britain case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britain's mind. I do believe that even if the 911 call substantiates some sort of an overact, which I still believe the defense has to put that in, but even if it does make an overact, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying, to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence, and I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call and testify a domestic violence expert. That domestic violence expert is going to educate the jury, in fact, he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Miss Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Miss Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Miss Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy.
They're playing heads
up. The
up.
domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse. And you begin to develop a survival instinct for it. So that's why you employ the get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal, was Ashley Benefield concerned about the release of the Broder report? Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal, by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions, some people call them spontaneous statements. and therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that.
This judge does not help out the attorneys at all.
I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's a issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order.
Affirmative defense, the burden shifts on that. Burden everywhere. Everybody has the burden. Very select portions shift to the defendant.
And this is, again, Smith, 606 Southern 2nd, 641. And this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing, 577 Southern 2nd, 682, and in that situation, the evidence was kept out, and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the Victim was unable to obtain cocaine. He became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm, or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd 420, and this is at 422 and 423. It's first DCA 1996. And it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence
I think it might come in.
And unfortunately, it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the...
I guess you can ask, but I'm in the middle of a ruling.
Okay, well, I think it may be relevant, helpful.
Okay.
It's like I'm talking here.
I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay. So.
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us, would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it
saying the
can?
presumption should be in favor of the defendant.
I think the defense is entitled to the benefit of the doubt. And in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research. And this may be the case that ultimately,
Judge says,
if
where
it
was
gets
I?
to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Thank you.
Okay, so this was outside the scope of cross.
If in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness the rest of what was taken out the add back.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right. So I just to put defense on notice that may be an issue.
That was a jab. If you do manage to get this in later on
So
in the
we're
trial, we want
bring-
everything in. Just be aware of that. We're going to get every bit of it.
We're going to bring the witness back in,
Still on the first witness of the day,
and you can resume your cross.
Sergeant Keyless. At least we're in cross-examination. So what was just ruled was the defense was about to present to the witness some WhatsApp text messages that the state had not talked about, and they're sort of a different topic. The judge ruled they can't come in yet.
Run the jury in and out for naught. I've shown Suzanne the remaining aspect of my cross, anticipating there may be some objection to it.
And I would have an objection.
You do?
Yes.
Well, cool. Can you step back out? Sure. Same rules.
Judge is like, cool, we get another objection. Witness getting his steps in, walking in and out. It's been a couple times now. So now we're going to argue over what Mr. Taylor's going to do next with this cross-examination, what he's trying to go into.
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, and maybe the defense can confirm, I believe these are supposed Google searches or internet searches for certain subjects.
Yep.
They're on
Yes,
the
they're on
phone.
the phone,
And
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry.
2020, Your Honor.
The first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, with a parent with an abuser.
Months
The
before the
next one
shooting.
was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent
Yes.
by Doug Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
Yeah, that one was shown by the state. They just moved past it a little quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming out.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020, and the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Perotta's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then on 5/11/20, asked Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project, and 6 tips on 5/11/20 to help you co-parent with an abusive ex. So, the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the training. Once the 9/11 tape came in, which said my husband attacked me and I shot him, together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing a murderous...
You said I excluded them? I did not exclude them.
You said they don't come in right now.
Introduce them.
I said not now.
No,
at this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position.
Go ahead, as soon as you wrap it up.
Now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have, in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence,
I agree with him here.
then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Ms. Benefield was different She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response?
Judge, the reason this should not come in is the exact same reason that you just ruled on last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason.
What would be the situation where it could come in?
Could I please see the exhibit?
Of course.
I like that the judge isn't just rubber stamping this and saying, basically the same argument, denied. He's weighing every single objection. When the judge says it doesn't come in now, it can't come in now, I have to ask, what would be the scenario where it could come in? This is a product of the witness who's currently on the stand. It's extraction from the cell phone. Why should it not come in? I think this would be something that would be overturned in an appellate decision as well.
And the purpose of offering defense exhibit 4A is to prove that Ms. Benefield actually made those searches?
To show state of mind.
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
I don't know how he could allow this and not allow the previous one. You'd have to reverse his previous ruling if he allows this.
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone. And the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. We still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay.
This will force her to take the stand.
So at this point, I'm going to rule that they're not admissible.
That forces her to take the stand. It's coming in if she takes the stand.
I have no further questions of Sergeant Keeler. I would like to make a proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read defendant's Exhibit 2, anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Keeler.
Can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
If we could just make a copy and enter it in.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I had marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, yes. These are text from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer.
Correct.
Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes. Composite.
State, for purposes of the proffer, do you believe that Detective Keyless would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
Yes, he
would. I believe he would, Judge. I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right. Is that sufficient for your proffer?
Yes, sir.
Do you want Keyless to stay under subpoena?
Yes. Yes. Say yes, Mr. Taylor. That's a hard yes right now.
Because I want to give him the right instructions.
Yes.
All right. Can you have Detective Keyless come back in?
You might need him to.
I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
Different.
That's why I didn't.
Sergeant, I'm sorry. Just right in front of me. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you.
I think this was a failure by the defense here. That was a big fail for the defense.
Oh, hold on.
Let him leave.
The clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
text message,
the What's Now apps, WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
It's a composite.
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want?
Well, I'd like to have it on there because they showed it, but they showed it very quickly.
Oh.
Defendant's Exhibit 5, which is one of the last, I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Thank you, Madam Clerk, for catching that.
Well, it's...
Right, 5 is in, 3 and 4 are proffers.
When you say, Your Honor, that Exhibit 5 is in, for purposes of proffer.
No, for evidence.
Yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible.
Okay.
Because it was shown.
Yeah.
State you showed it.
It's already in.
Right, it was shown.
So this is just a printout of...
Okay, but I think he hasn't... Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just be as a problem.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay.
It's stipulated, but I'm not receiving it. Judge is confused. Okay.
All right.
If we get a break, I want to explain what happened here, this whole proffer. I love that the judge explained where he was thinking on this, on the 3 prongs of evidence.
All right, Sadie, you ready to call your next witness?
Yes, Judge.
Ready to bring the jury in?
Yes.
All right, let's bring him in.
I think we are going to use the, I know we just opened the blinds, but.
You will bring the jury.
Authenticity, relevance, and admissibility are the 3 factors that are measured that he's weighing this evidence on. And he's kept it out only on the admissibility side because these are basically statements from this defendant. She needs to testify if she wants some of these things in. The other 2, it nailed those 2, and I think the failure was that I think there is an argument to be made to let it in without her testifying. But Mr. Taylor did not make that argument well. He didn't provide the judge with the pieces he needed to put this together. And this judge is not helping the lawyers out at all. He does not volunteer and say, well, do you want to call the media guy as a witness? He doesn't do that. They should. They should call him. And previously this morning, they should have called the media guy, dragged him in there and talked to him. But he bases the ruling based on the argument and the testimony that's in front of him. And defense is doing a poor job initially in the argument. Sometimes their arguments are great, and I think a couple of them were good, but he just didn't say the right words to get the judge into that mindset where he needed to make the ruling in their favor.
All right, you all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything you talked about?
No.
All right. When we were last here, Detective Keyless had finished his testimony, and now we'll let the state call their next witness.
State would call Dr. Vega.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Get his name one more time here.
Hello, sir. I'm Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everything.
I will. Thank you, Your Honor.
Good afternoon, Doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the Chief Medical Examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a Chief Medical Examiner, or at least, yes, as a Chief Medical Examiner?
So as the Chief Medical Examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
Okay. And so that was my next question. The percentage, do you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And I'm going to draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination of the body in its state as it arrives, at our facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
We may see some autopsy photos here. I'm not sure.
Dr. Vega, I'm showing you what's been pre-marked as states 86 through
Can I see the photographs, please?
Yes, they're saying this is the one you just, when you look at that.
Was there an objection? The screen's been lowered. I want to hear about the time of death. I want to hear about the trajectory of the bullet through his body from entrance to exit point.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
All right, they're going to approach and talk about that objection. I'm just hammering out some details with a pool feed for the Corey Richardson's trial, which I'm super excited about. We've got 2 hearings coming up in August in Corey Richardson's trial, and we're in like Flynn on those ones. So I'd like to be there in person. But I will just say on that trial, the news station that is the pool photographer for that trial is KUTV. They are amazing to work with. Absolutely amazing. Just big shout out. I worked for their competitor in that same market, but KUTV has been awesome to work with. Big fans of them. As well as the trajectory in the house. Yes, we're not going to hear about that from the ME. We got that from the crime scene investigator, but that's it. Let's see. Apparently there's a giant fire happening. What state? Pretty much all the West has fires right now if you look on the map. There's a lot of them. Just as a little side note, the pool cameraman can, when there's a pool feed and everyone sort of shares the feed, sometimes that pool feed will say, "Oh, all right, I'll share, but you've got to pay half of our expenses." You know, you have to work it out with them, and it's sort of like on your own outside of court. If there's a problem, you all get kicked out, and so it's in everyone's interest to work it out. But last time we had an issue with KUTV, there was a hearing that I could not go to, and I wanted a copy of. They're like, "Hey, we'll just send it to you on our WeTransfer. We'll just send you the high definition files. Just give you your email. We'll transfer it over to you." It's just like, wow, thank you. A lot of times they're like, if you're not here with your own smart, your little media card, and the time it happens, you don't get a copy. And KUTV just is not like that at all. So super excited to work with them again and be there in person. I think I know a couple of the employees out there as well, so that's going to be great. But we're going to, just as an update, we're going to do 2 things. We're going to record Corey Richardson's live in the courtroom. Like I'll bring a hyperdeck to record Corey Richardson's, and then we are also going to attempt to live stream from the courtroom as it's happening using a bonded cellular encoder, a live view device. But if the live view fails for any reason, we'll have the high definition copy.
Well, she's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length. That's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
It was 169 pounds.
And the
that was
length?
high school for me.
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as you,
it's an easy conversion,
as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you.
Her hearings are in August. I don't know her trial date yet.
Sorry, Judge. Just bear with me 1 second. Recovery, we're going to try this one more time. I'm going to show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
Yes, I do recognize them.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you, Your Honor. At this time, I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment.
Okay.
Here's did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
Okay. And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
Uh-oh.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been pre-marked as states 14. Would you take a look at that item and tell me if you recognize it?
Guys, if there's somebody in chat that has some comments you don't appreciate, feel free to block them. We don't need to discuss it in chat. The mods are doing all they can to keep it nice. We ask everyone to be respectful. No name calling. Be mindful there.
And how do you recognize it?
A lot of people have different experiences.
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
Thank you. And, Doctor, I'm going to show you states 95.
I think he said
is
no
this
objection.
the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Zoom out, camera, zoom out. There we go. Got it. Not too far.
And where would the exit wound be?
Well, no exit. But
I'm sorry, the projectile.
The projectile.
Yes, sir.
My mobility is a little limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn
Definitely
back
shot on
so we
the
can see
side.
the entrance again?
Yeah.
Thank you, sir.
You're welcome.
He was turned sideways when that bullet hit him. It doesn't mean he wasn't facing her when she started firing. She fired a lot of rounds.
You
that did
said
not
that
hit him.
the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal?
Yes.
Was it, it wasn't front to back like it went straight through. Can you describe it?
Certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body.
Thank you.
The spine.
His spine.
Yes.
And would that injury have been immediately fatal?
Probably not.
Just debilitating.
And would it have incapacitated if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then finally you said he was also shot in the leg. Is that correct?
That's correct.
Okay. So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation-wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg.
We're seeing the back of your head, actually.
It's, excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different.
And how so?
Because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast-moving awl or punch, in that it goes in and it almost drills a hole into the skin, but when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically, the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it? So
the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out, and that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you.
Now we're showing
If you're
some
more
leg.
comfortable, you can see here. Yes, sir.
We might see a picture here.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
Thank you, Judge. So on me, the entrance was down here.
If it helps, I can put my finger there.
Okay. And the exit here.
This is a picture we need.
Here to here.
Yes.
And so that's You said slightly up or up.
It's upward from
That's
the right
important.
toward the left, and and from back to front. Yes, largely all three of those components.
Thank you.
they
Well, you
should
know what,
hire
Dr.
a
Vega, while you're
model for
down here,
these.
just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I've made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you.
In other trials, we've seen a
Thank you so
skeleton
much,
brought
Dr.
in
Vega. I appreciate that.
with
Mr.
a
Taylor, were you
trajectory
able to see
rod
both of
put
those
through it.
demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you States 15. You'll take a look at that and tell me if you recognize it.
It seems to me that it's more likely that if she shot multiple times, that successive shots would have been higher.
Yes, I do.
And how do you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
Meaning
And
the lead shot might have
how
been
does this
first.
differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter States 15.
No objection.
Received.
Thank you.
Luca, the state can't force her to
And
testify.
Dr. Vega, I
she
have a
can
photo
if she wants to testify. She has the right
Of
to.
States, this is States 97. Is that the same item that is in States 15?
Yes.
Thank you.
Big
Did
shout out
you
to
find
Krista, who's our internet
any-
owner today,
I'm
first
gonna
in
go
chat.
back
Thank you so
to
much,
the-
Krista.
Well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
The absence it reflects the same principle in either injury, and what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require, the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And, Your Honor, may I have just one moment?
Yes.
Leg injury back to front, in the calf, out the knee. Could be from a crouched position that he was in,
Dr.
but he would be
Vega,
facing away from her.
Hypothetically, Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
That's not where I would
If
assume.
this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell, when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And were there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
The question they asked about, is it possible for him to
I
get
don't have
shot in
anything
the
else,
leg
Dr. Vega. Thank you. The
by
defense
falling
may.
back and having his legs flip up in the air?
Mr. Taylor,
I don't think
cross.
the witness
And
understood.
of course, the question is, do you need this?
I do not.
We're raising the screen. What's up?
Yes, sir.
Afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Objection
Very nice,
relevance.
thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct, yes.
Muscular build.
I don't think I used that terminology. I think I just talked about the weight and the body length.
I want to ask you, you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3-foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his expertise.
I'd sustain that.
I'll allow it if the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable.
Objection, close for legal.
I'll sustain.
Justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because I've asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
That's big. It's not.
Let me just check, Your Honor. I think that might conclude.
The roundhouse kick theory, I don't think holds up based on where he was located, the difficulty of pulling that maneuver off in a hallway, and the lack of stippling, which would have been present if she was close enough for him to kick her. I don't think that would work. Although it does get his leg in the proper position, possibly for the injury.
Last question with respect to the leg. You've told us that the gun would had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Beck.
The state tried to do an end run to prevent that from him to saying that, but
Dr. Vega,
got it in.
I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes, so the weapon did have to be in front of him, but even more so it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
I won't tell anybody.
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir,
No time of death.
Subpoena, you're free to go.
No temperature. I may not have been calculated. May not have been measured until a time where it would sort
General,
of.
we're switching. Could the deputy pass 14 and 15? Would you mind?
Oh, pass, you mean
Yes.
to the jury?
Sorry,
I wasn't
publish.
quite sure what you meant. Publish.
Sorry, I meant pass through the jury. Yes, sir.
All right. Members of the jury, as with yesterday, we're going to pass these around. These will go back with you during your deliberations.
So,
All right, State, your next witness.
Here we go.
Daniel Hausdorff.
Got one more. While this witness is coming in, we may see things in the movies where somebody gets shot and they like flip on the air or something. That's typically not how it happens. Even with a hollow point bullet that transfers a lot of energy to the body, it would seem unnatural for the body to flip and the legs go up in the air like over the head as he's falling. I don't think that's going to be a believable scenario.
Madam Clerk, sorry, are you sure the witness in or not? Thank you.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Hello, sir. How you doing, Judge? My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
Hold on one second.
Oh, I'm sorry.
Go ahead. You all finish up. So you're going to wait a second.
Yeah. I apologize, Judge.
Jury's still looking at the bullets that were
I don't want anybody
collected
to
from
feel
the
rushed.
medical
And
examination.
like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the Firearms section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the Firearms Division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test fire the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there, I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst since August of 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases for firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And
they shoot
so
as
the
fast
cartridge
as you can
case
pull the
leaves
trigger.
the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given the unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case. And everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory .45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FDLE case number, item number, and my initials and my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
Yeah, it's empty.
I was going to say there's gloves here if you need them.
It's okay.
It's too
Again,
late.
Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
He's like, it's okay. I'm just going to grab the weapon.
Mr. Hausdorff?
Yes, ma'am.
Would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and ignite the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fired cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it will go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Mom. Can we approach for a moment?
Of course.
I'm sorry, Your Honor. Can we approach for a moment? Not sure what they're going to talk about here. That was a very good explanation. I think the witness is very comfortable with firearms, both in handling. I think he did a fair job safety-wise. He did put his hand in front of the gun a couple times, but I think overall, a very good demonstration. That would be, that's not the 380. This is going to be the 45. And I'm just looking at that. You know what? Let me rewind on this. I want to see, just for me, I'm not rewinding for you guys, sorry. I just want to see if they said it was a 10 round. It's got to be a stagger stack.
Mr. Hausdorff, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly.
Don't jar the back of your firearm.
Since I test fired 3 times, I didn't have that issue when I was firing.
If it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3.
Look like an SD4.
Through
XD4. That's an XD.
You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined.
She had 2 XDs. She had I think a 380.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FDLE case number, item number, and my initials and my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
They're hot.
And velocity is the speed in which they travel?
Yes, ma'am.
They have more gunpowder in them.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just so we can talk about that part?
Yes.
We're really going. And so you said you first look at test to test, and can you explain slowly what you're looking for to compare those, to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm. as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10, and 14. Would you like to take a look at these items?
Yes. Thank you.
And tell me if there are items that you've previously seen in your lab.
I've seen some great videos of firearms instructors shooting themselves in the leg.
Yes, ma'am.
All the rules
And how
all
do
the
you
time.
know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact, so I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
No, I think the first time you said fired in and then you said fired from.
The reason I just say in is the cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical?
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value for microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received one T-shirt, and what I will do is I will visually, microscopically, and chemically test the T-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was unable to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This states too, is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
gunpowder.
Gunpowder. Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And
besides the hole, no, ma'am.
What might explain the lack of gunshot powder on this shirt?
This is big.
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt.
Wow,
it could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
Okay, so that distance goes to the argument of, was she in danger? Was he attacking her?
I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross. Very briefly, so Mr. Houseworth, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Reader?
No, sir. Thank you.
Can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you. State.
Your Honor, at this time, the state rests.
All right.
We're done.
Members of the jury, the state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics we've heard anything about. And don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes. You all can have a seat.
Now it's time for the motion for directed verdict, which will be denied.
All right, before, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, We also, if I do deny it, I want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through.
It's the judgment of acquittal motion.
We've still got the
it's
issue
basically asking the judge to throw it out because the
Vicky
state didn't prove their
Mechanic,
case.
trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss, the expert.
Ferris.
Ferris, Ron.
I don't know where I got Bliss.
He's a police officer.
You smushed them together.
Okay. We've got that, and
It's not going to happen. He can argue all he wants for the record, but it's not going to be granted.
I have another Richardson issue.
Judge is going through his notes.
It just says 391 emails. Okay, Richardson emails. And then we also have the issue of Faith Brown. And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own
Impeach.
her own explanation for them.
Yes.
Which would be inconsistent with the testimony Ms. Murphy gave.
Yeah. And
She's a judicial assistant.
Oh, sorry.
In an effort to protect Ms. Benefield, because we've yet to deal with this, I issued another subpoena to the JA yesterday, so I've already heard from Ms. Floyd, who has filed, the court probably hasn't caught up with it yet. She's filed another motion to quash, but she's also filed for sanctions. So the court may want to deal with that.
Okay. Well, I guess we'll eventually just kind of wait and see if her presence is obviated by by Ms. Brown's testimony. I don't want to make assumptions.
I understand.
So, I was going to kind of give you all the option. If you want to, I can give you the break that I'm giving them. You all can talk about, do we want to do some more work tonight? How late do we want to stay? Do we want to get all the way through this? Would it be better that we took care of some of this in the morning? Because I don't know when when is Mr. Ferris going to be available?
I would anticipate when we decide to call them, they'll be available.
Okay.
Yeah.
All right.
I think we could do the JA, Your Honor, and the other stuff. We could do the JA, and maybe if you want to do the discovery now. I certainly wouldn't mind breaking a little early. I would guess that would be fine with them also.
Can I stop you? When you say JA, I think judicial assistant.
JOA.
JOA. Okay. I just want to clarify.
Sorry.
Thank you.
Well, yeah, I think let's at least get that done this evening.
Yes. Okay. That was going to be, I was trying to figure out if you meant JOA or JA.
Yeah, sorry. That's the reason why breaking early probably be good.
Right. So let me give you all a break.
Thank you.
Absolutely. When the jury comes back, I'll let them know that we have some work to do on our part. We're not leaving early. We've got stuff to do. And then we can hit the ground running tomorrow morning. Just so you know, because it's as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, a 33-day motion I'll have to hear first thing. If it hasn't been obviated by the filing of the information or a null pros, I don't know yet.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it, but you set it for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
All right, so judgment of acquittal, that's what's coming up next as we look at the wall for a moment. This is very rare to ever be granted. It basically is only granted in the most, extreme of situations, because the rules for a judgment of acquittal, that is the judge basically saying at this point in the trial, first of all, it's a motion made by the defense to the judge saying, Judge, at this point in the trial, we have to ask that you just throw this case out, that you call quits. But the jury doesn't need to listen to any of this because the state did not prove their case. That's what they're saying. So they make their argument. They say, this is why we think they didn't prove their case. And they'll say there's nothing that, they're going to try to say there's nothing that that said that it was that they didn't prove that he died. They didn't prove that it was our my client that did it. They're going to make all their arguments that they can, but the flip side of that is if there is any evidence at all that go to each one of the elements of the charges, any evidence that can be presented to the jury, the judge has to look at that evidence in the light most favorable to the state, okay, the prosecution. And so if there's anything towards it at all, it goes to the jury. You would have to have a complete failure on the part of the prosecution in order for a judgment of acquittal to be granted, or at least a case that just should not have made it to court. So it's not going to be granted, but they can be quite lengthy. It's like a gripe session, really. And we know that Mr. Taylor can be quite verbose when he gets an opportunity to speak without a time limit. So that's going to happen here next. The judge has a lot of things on his list. He said he's got the Richardson hearing. That's where the state is saying that things were not turned over to them in a timely manner as they were supposed to be. He's got, and possibly vice versa, discovery violations. He's got some stuff about some decisions that need to be made on a few other issues that are just pending. He's kept notes on everything that he stuck a pin in. He's got all his pins lined up. And so we've got a lot of things we're going to go through. Might all happen, or a lot of them might happen tonight. Motion for a poll in the chat. What's the motion? I will hear your motion. Braxton Heaps says, good afternoon, everyone. I want to thank everyone for the support while I've been working on getting a job. I heard back today that I got the job. That'll be starting on Monday. Braxton, that is awesome. It means so much to me to be in this great community. Braxton, thank you. I saw you last night on with Ada, and loved it. It was wonderful. I was painting, so I wasn't able to stay in chat very long, but I was listening, and loved that you were on there with that as well. Congratulations on the job. Knew you'd nail that one. You're exactly who they're looking for, and give you 2 years, you're going to own the place. But congratulations on that. All right, let's see. This is going to ruin the tour. Says, well, I guess not convinced since state is done. Where did they leave? What should they have gone into, in your mind? What should they have presented to the jury that they didn't do? Okay, the motion is to poll the chat if the prosecution has proven the case. That's a great poll. Let me go ahead and put that up now. We've got just about 5 minutes or so before they come back. Maybe a tiny bit more. Starting a poll. Did the state prove their case? It's just a yes, no. Did the state prove your case? All right. Kate Leray says, I missed watching the last couple of days. Was there any DV reports made by her about Doug? Yes, there were. The reports that came in were not really evidence in this trial. It sort of came in that they were raised in the other proceeding that was going on, the custody issue. That court investigated every complaint that came in and basically said they were unfounded. I think the judge's words in that was that there wasn't a scintilla of evidence supporting those claims. I will say it does not mean that nothing happened. It just means there was no evidence that it happened. And it's a strong point on the prosecution side that they're trying to say that Ashley made all this up and that she made up these stories to try to get him in trouble, get him out of her life. And when that didn't work, she resorted to this very final measure. When do they read jury instructions? It will probably be, he might mention them today. He might mention them Friday. but they'll probably go over them in the evening, a day or two before they rest. We're just barely finished with the state. I imagine we have 2 to 3 days at least of defense witnesses, some of them expert witnesses, which will take a very long time because they get paid by the hour. We have a lawyer who's getting paid by the hour and an expert witness is getting paid by the hour. It's a bad scenario. Lily Tree says, as I understand it, they only need to prove that she killed him at this point. If she has an affirmative defense, meaning a justification for it, which I believe is what they're doing here. They tried to do self-defense, and that failed at the pretrial self-defense hearing. But she's now saying battered wife as the justification. I think the state has to prove that it wasn't that. And that's why we got all the emails that came in, the text messages, the video of them playing heads up at the restaurant a week before. I think that was the state's testimony saying everything was fine. There was no problems other than that she wanted him out of her life. I love the word scintilla. Who said that? Scintilla, colloquy. There are a couple of really good words that come up in court a lot. Which attorney is the defense? The older gentleman who has a slower speaking style, that is Mr. Taylor. His sidekick, who is seated behind him one row back because he's not a lawyer, that's Mr. O'Keefe. Mr. O'Keefe does a lot of the heavy lifting on the defense side. That makes up the defense team for Miss Ashley Benefield. And then we have 2 prosecutors on the state side. Both of those ladies are doing a fantastic job for the state. Let's see. The defense said it wasn't battered spouse. Okay, well, they've basically stipulated that, I mean, her own testimony that I shot him, he came at me and I shot him, has come in, and they've been seeking that to get that in. So they're not saying this isn't a whodunit by any means. This is she did it. The question is, why was it justified? As far as the gunshots, we were waiting for the ME, and we finally heard from him. The gunshot trajectory, I think it's important that he was not shot in the back, but he was shot in the back of the leg. And that shot went in the calf and out the knee, out by the knee. So it went sort of an upward trajectory in the back of the leg. That can happen. Imagine if someone was running away from you with their leg in that position. If the leg, let's see, where would my feet be? If this is my foot right here, the leg can bend at the knee, right? And if you get shot in the calf, even though it's going down, it's possible that it can get shot in the calf and exit the knee. And once straightened, the trajectory looks up, but when bent, it was down or horizontal. That was a very bad. I need a model. I need to get like a little dummy that we can position, like a Gumby, and maybe, I don't know, barbecue skewers for trajectory rods. Is that a good idea? Is that too graphic? So that's possible. Instead of talking about that or saying that he was like squatted down and was shot while he was like hunched down or squatted down on the floor, both the prosecution and defense asked the medical examiner, would it be possible that if he was shot and was falling backwards, and arms and legs up in the air, his legs shot up above his head, and then he was shot, sort of like, here's his legs, right? So he's standing here, heads up here. Okay, are you with me here? Let's do. I'm not very good with finger puppets. I probably should get the puppets out. But if his head's up here and he gets shot and he's falling backwards, this is his head. Here's his legs. That his legs went up in the air and then got shot like that. That would account for the upward direction. It doesn't make sense. Getting shot does not like flip you head over heels unless you're shot with a cannon. A .45 is a big gun, even with it making contact with major structure in your body, like your backbone, which it did. I don't think that would have flipped his legs up into the air, like they say here. Let's see. Look, Luca, hopefully we answered this earlier for you. You said, I'm not familiar with the American laws. Can't the state call her to take the stand? Love to learn new things. You have the right to remain silent in the United States. They can't force you to say anything. incriminating. So you say, I would plead the fifth, but you have the right to remain silent. And so they can't really call you. She can testify, and she has the right to testify in her own defense. We're going to hear the colloquy with the judge where he sits down and talks to her and says, you have to make this decision because although you have two rights, you can only choose one of them because you can either remain silent or you can speak. They're mutually exclusive. So he's going to talk about those and talk about her choice and what each one will mean for how he proceeds, especially with instructions to the jury based on her decision. Jordy Minority says, wow, I'm not in the minority once again. I may need a name change. I'm with Kathy from Gossip and Rumor and Innuendo. I can't let him go of punching dog. I can't let go of him punching the dog. That came in. I think the defense has done a good job of bringing in something that shows that Doug was not all the flowers and roses that were maybe portrayed in the text messages. Ivan Victor says if you start stabbing Gumby with barbecue skewers, I'm unsubscribing. Maybe I need like a crochet doll. I don't know. I think the barbecue skewers is a good option, but I mean I'm not trying to do like voodoo or anything, but sometimes we just need to demonstrate how things work, and my hands, I can't bend them into that shape. We never got the time of death. Why? Why do we not get the time of death when the state brought out in testimony, almost it looks like intentionally, their star piece of evidence? Who was it that brought that in? Let me go back and see who he was. That was on day one. We had Detective James Ackerman. Says he was cold to the touch. We went in, we were the first people in, cleared the house, checked the body. He was cold to the touch. Why didn't we have testimony that then followed up and said, yeah, he had been dead longer than we expected based on when the police arrived and the events we were told? Why was that not brought in? I think that would have been much more compelling had they done that. Let's see. Can someone explain, why are there two of me? There are. Can someone explain the difference between self-defense and battered wife? Wouldn't self-defense be a natural reaction from battered wife? I think battered wife defense allows for basically someone who's pushed to the limit and can't take it anymore and might be acting out in a situation where it wasn't quite as imminent a threat in the very moment. As when it was taken. That's my understanding of that one. Whereas self-defense would be, fight or flight. I couldn't get away, so I fought and shot back. A battered wife would be something that, like, over time, this happens. This was the fear. She was worried that was going to happen. She took a step because of her fear. She survived last time, but will she survive the next one? That would be sort of the mindset that went into a decision in a battered wife defense, I think. We are going to have a defense domestic violence expert being brought in. That's one that we know is coming. Mary Murphy, I think she will testify. I think she has to. There are some key parts in their testimony that, say, like the WhatsApp messages. Those can come in if she testifies. She can testify to that. She can authenticate those. They're definitely relevant. If she takes the stand, that covers all 3 points of the admissibility for that evidence. So I think she has to do that, especially if it's critical for their case. Yes, battered wife is a slow buildup of unaliving. Yeah. Battered wife isn't a defense; it's a psychological condition. Self-defense is a defense in law. So it would fall under self-defense then. I think the judge all the way made an absolutely amazing analogy when he was talking about the burden and how the burden shifts. Just tie this. Let's turn this on here. Tie that. Cut back. Okay. How the burden shifts as when we talk about self-defense. If a defendant says, hey, this was a self-defense case, that is an affirmative defense where previously everything had to be the burden was all entirely on the state to prove that the crime occurred. You say, but yes, I shot him, but I had a defense. This was in self-defense. It now turns to you, and you have to say, prove this is self-defense. And you have to present your self-defense case and say, I was being attacked, I've got these injuries, this is what happened. And then the state, this burden goes back to the state. They have to prove it's not self-defense in addition to proving that first element of the crime, which is pretty easy to prove when you've said, yeah, I did it, but here's why. But the burden for both of them lands on them. Megan, you can find my P.O. Box. Let's see. I can find it somewhere. I think one of the mods can do the link. I think it's P.O. Box 775. I can't remember off the top of my head. If one of the mods can do the address link, that would be great. Thank you very much. I have to get something out of the post office. I know I have something. There's a notice that I have a package, and every time I get there, they're closed. So maybe if court ends early today before 4:30, I can get there and pick it up today. All right. No neighbors heard anything. Nope. This is a nice neighborhood. Big houses, large yards, is my understanding. And this happened indoors. So, although somebody, if you had stopped them in the moment, they might have said, I heard a pop sound or something like that, or a couple pops. It probably would not have been loud enough, unless it happened in the front yard, that anyone would have noticed at all. A gunshot inside the house generally can't be heard very far unless you have windows like mine. Let's see. Whiteboard with stick figures. I can't draw stick figures for the life of me. Plus 3D stick figures are problematic. Time of death is arranged, not exact timing, says Genjo. The window of time wasn't big enough to make a huge thing in the trial with little to gain. Just my opinion. I was thinking, if he had been dead for, 4 hours before police arrived, that would do a couple things. First of all, it would probably implicate her mom. It would probably implicate her mom in being aware of it.
We have a witness issue. Faith Brown is available now. She's not available tomorrow. She will not be a long witness. One which the court would entertain. However Your Honor wants to do it, while we have the jury here, I can call her. Or case law even says the Supreme Court case of State v. Smith, the court could call her as a court witness. And when she's done, then we could do the JOA or we could do it in reverse.
I'm sorry, did you say she's here?
She may be outside now. She's on her way over.
I would at least like a few minutes to speak to her based on the fact that I didn't know about her.
Yeah, of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented before.
Yep.
Not Bliss, Ferris.
I just don't know how we can accomplish that when the evidence that they're attempting to seek also, I think, was never provided to the state. That's the other subject of your Richardson hearing, is those emails from the sealed hearing that we've now had access to. I think had to have been obtained by the defense from his Faith Brown, and because the state's never gotten those until yesterday.
What was the date? September 30th of 20?
I think the issue of the dog being punched was admission by Doug in the civil suit.
You're going to have to show me where, because I don't look in my...
Well, we don't need the back and forth. I'm trying to figure out...
I don't know how we have access to this.
Listen, this is for me, who typically is just, let's start the trial, let's go, let's get this thing done, not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be outstanding up here.
My first one of the trial.
No, that really would work out pretty well, because I got witnesses like planes stacked, and my head is spinning over it. So, yeah, that would be...
And just so you know, State, this is also what I'm contemplating is the fact that whether or not I find any kind of Richardson violation for the emails or whatever the other one was, I can't remember what the other one was, then you have the entire weekend to go through everything. And we kind of hit reset, and then defense, you can come forward with your obligations. If it's a witness you expect to call, a document, a tangible object you intend to use at a hearing or trial, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me, but what do you think?
And Judge, I would be fine with that. My only concern is that I thought some of the alternates had conflicts next week, and I don't remember, and maybe it was actual seated jurors, I can't remember.
No.
There were conflicts that started next week,
but I don't know.
I'm not sure what they were.
It started Monday or Wednesday or...
I think the juror that the gentleman we had last today, he had a conference starting Monday out of town. Not that we would be done tomorrow anyways, but...
So much noise.
Judge, I can only tell you that for my purposes, I believe I could have pretty much, even though I had some problems, I think if we hit the ground running Monday morning, I think I can move this thing pretty good.
Right, but does that mean finish Monday or finish Tuesday?
Oh, definitely don't. Definitely don't finish Monday.
All right, so defense case done Monday. And then
we close Tuesday?
I think that might be optimistic. I think Wednesday probably is more realistic.
Okay.
Right, so finish defense case Monday, but then we have jury instructions.
Right.
Oh, can't. I apologize, sir.
Okay.
So you expect to finish Tuesday?
I hope to finish Tuesday. I didn't mislead the court when I said I had a number of witnesses. I will do my best to end it on Tuesday, but it's going to be challenging.
Late Tuesday rest, closing arguments Wednesday?
Yes, I mean, you're correct in identifying that some of the jurors expressed that they had time restraints, but however, both sides chose to keep them.
Well, and I think what would Wednesday on the calendar be?
Next Wednesday is the 31st.
I think we still should be okay. I know for me, I had some scheduling issues at or around the 1st. So
right,
we can try to finish the case up Tuesday, if not early Wednesday.
Judge, I just think if we're talking about the defense not even being done on Tuesday, I don't want to take a whole day with nothing. I mean, but I recognize that I don't make the final decision, but that would be my opinion, is to not go a full day without doing any trial tomorrow. But.
All right. Do you have some witnesses, defense, that you could call tomorrow afternoon?
Just one.
Yes.
All right. So what we could do is we could do some work this evening. Again, depending on what my ruling is on the JOA, we come back tomorrow morning. Oh, and I checked, the information was filed, so I do not have the hearing at 8:30. But we can start first thing tomorrow morning with these hearings that we need to get through. Go to lunch, and I tell the jury to be back here at like 1 o'clock. And then we start the the defense's case in chief around 1. And go as far as we can. Okay?
Okay.
You're nodding your heads, but I'm...
Yes, sorry.
Okay. All right, so if you could, let's bring the jury back out. I'm going to release them for the evening and ask them to be back at the jury assembly room tomorrow about 12:45 with the goal of having them up here around 1 o'clock.
All right, so I'm sorry, Judge. I'm wondering, where does that leave me with Faith Brown?
On Monday.
Well, if she's not available tomorrow...
She's not. Is she available Monday? No, she's out the whole Tuesday.
She's here now.
I'd say maybe call her Monday.
Yeah, that'd be fine. I just want to make sure she's available on Monday.
Sure.
Yeah.
Right. Is she under subpoena?
No.
Judge, I just feel like the state doesn't have the option to say our witnesses are not available. I mean, if they're traveling or the next morning or whatever, but to delay an entire day because they didn't make arrangements with their witness, who they haven't listed, seems outrageous.
No, hold on.
Okay.
This
Poor
is
argument.
me, because I want to get these, I got a bunch of hearings that I got to get done, including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we can just call her Monday, and that'll give you a chance to get a deposition done.
She's not available Monday.
Did he step out to ask? What did he?
Where did
he
Mr.
asking?
O'Keefe go?
You want me to bring her in?
No, I just need to know, is that the plan?
Yeah.
So, because I want to let the jury go, tell them to be here tomorrow at 12:45.
He's out there asking her now. And if there's no chance that we can put her on today, then...
No, I agree with the state. She hasn't even been listed. So I certainly will allow you to call her because I understand the reason why you need her. But I think the state, again, hearkening back to that due process concept, they have a right to speak with her and take her deposition.
Okay.
All right, but they didn't need to call the person until the state's witness, according to defense, lied on the stand about an email exchange. Now they're calling the person on the other side of that email to correct that. So this developed.
Can you give me a moment?
Of course.
Mr. Taylor's going to step out and talk to the witness. She's a judicial assistant. She's the one who's emailing Miss Murphy, I believe. It's going to be probably 5 minutes of testimony. Lily, I would say that she is not testifying. I think she is not testifying. Judge is giving completely changed the schedule around. Going to let the jury go home now, make tomorrow a work day. So that'll give the state time to question the judicial assistant, Ms. Faith. This is very crazy. We've got the Richardson hearing, which is very much like Brady, but it's specific to Florida. Thanks for the... Who was it that posted that? I thought I shared that already on the screen, but... Melissa Webb, thank you. Richardson violation is like a Brady violation, but it's the Richardson versus Florida, so it's a specific case to their state, so they use that one. Thought Friday is opening for Olympics. Yes, they are. if the witness is not going to be available before the case is over, and the judge won't allow her to be called today, but knows it's important, they should be able to, under rules for unavailable witness, make a deposition or something and bring in that deposition as testimony. I'm pretty sure Florida has rules to allow that. I know we saw it in the Maya trial. That was civil, but I agree. It is allowed to violate discovery because it's for impeachment. This issue, she would never be called unless the state's witness lied, and the state's witness did. She lied under oath. At least that's what the defense is arguing. They're going to try to prove that she did. Taylor's never coming back. He's headed to the weekend right now. Okay, smaller house, 1,500 square foot house on a small lot, nice neighborhood. Depending on how the house was built, a firearm being fired inside the house might still be very quiet outside the house. Zoom is a possibility. A lot of courts have gone away from that since it's not necessary anymore. Yes, the JA, separate from the JOA. The JA is the judicial assistant in the civil hearing that involved Doug and Ashley. That judicial assistant emailed back and forth scheduling stuff with the Miss Murphy, the lawyer for Doug. And when presented with those emails, the lawyer said no, that it was not scheduled, that we were going to just have this hearing on this date, or just deal with this on this date. When the defense believes that's exactly what the emails say. So now they're calling the other person on the email exchange, and that's Miss Faith, the judicial assistant, to get her to testify to say, yes, that is what we'd planned. And so they're using this witness to impeach Miss Murphy, which was the spicy witness. Probably one of the spicier ones of this whole trial. The JOA, we still have pending. That is the judgment of acquittal. That's a motion the defense is going to make, asking the judge to throw the case out, to rule that this doesn't need to go to the jury. We've seen enough because we haven't seen enough. The state has not proven the case, and thus we're going to throw it out. I don't know why they didn't subpoena her. I thought they said they did subpoena her. Then the state asked if she was under subpoena, and the defense said no. So I'm confused as to why Miss Faith is not subpoenaed. Poll results were 66% to 33%. The majority saying no, the state has not proven their case. Am I confusing the judicial assistant and Faith? I may be making a mistake there. Somebody could correct me. I didn't think they were calling her attorney in the civil suit. I remember he said he subpoenaed someone this morning. He put another subpoena out, probably to cover a different time frame, instead of just coming on a certain day, to cover on multiple days. Judge is sitting there saying the jury's waiting. I could be sending them home right now. What did the state need to prove again? With the judicial assistant, they wanted to prove that the contents of the email said that the court had scheduled to hear a specific matter on a certain date. Miss Murphy, if you remember, she said that wasn't what we were going to do. That was originally the plan, but the plan changed. So they're calling the other person in the email chain to say, yes, actually, that was the plan. It didn't change. That's just impeachment material. divorce lawyer. I remember judicial assistant. That's why we heard the JA versus JOA.
I'm happy to report, Your Honor, she will be available tomorrow at 9 o'clock. She's got a little window, so we're good.
All right.
So we're going to do all the motions this afternoon?
Yeah.
Thank you, Judge.
Yep.
Now can we bring the jury?
Hopefully she's available for you to speak with her. Do you want to step out and make those arrangements now?
I would, yes.
But while you're doing that, can one of you stay?
Yes, I'll
and I'm
stay.
going to tell the jury 12:45 tomorrow?
Let them go.
Well, no, wait a minute.
Right, now we have to have them here in the morning.
Now I need them here in the morning.
Yes.
Okay, all right. Hold on. I just want to make sure she's going to be available. Because you guys have every right and should be able to speak with her about her expected testimony. Did that come up during your conversations?
It might come up, but I'm sure she'll talk to the judge.
Go ahead.
I don't know, it's not committing college.
Mr. O'Keefe goes out, wants to be present for the
Your Honor,
questioning.
I feel like a vacation has been snatched away from me.
What?
I feel like a vacation has been snatched away from me. I was picturing having a walk.
I thought he said it was a work day. Judge did not laugh at the joke. Did not think it was funny. Man, this white noise waterfall stuff is killing me. Better we have the urinal microphone cranked to full volume. Another little fun fact, the judge uses a little set of hammers to type on his keyboard.
I think I'm about to catch a whooping.
I had to crank the volume for that one, Adam. About to catch a whooping. If you missed that sound effect from when this happened in the trial, you've got to go back and watch that. Defense attorney really stepped in it with the judge, and the judge said, "Do you want to say anything before I start speaking?" He's like, I think I'm about to catch a whooping. Wow. We got that sound clip. We got it. This is very interesting. It's funny how Mr. O'Keefe can act as part of the defense team when conferring with state and witnesses, but can't sit at counsel table during the trial. Just weird. Finally turns the noise down. And back up it goes.
Is she out there? Okay. Judge. It's never easy. We have a small complication. It's an issue that Your Honor's going to have to deal with. She was not under subpoena by either side and was not told that because she wasn't expecting to be witness, that she could not observe the proceedings. So she has watched some of the proceedings.
Oh, no.
Once I contacted her, told her that we needed her, we told her to stop, and of course she was conformed to that. I don't know if that presents an issue, but I want to disclose that to the court, and Ms. Brown wanted me to as well.
Okay. You don't have to say anything now. I'm just, you're on notice. We're just waiting for her, Ms. O'Donnell, to come back in and confirm that we can get, you guys can speak with her tonight or tomorrow.
What just happened was...
I need to know that answer so then I can decide, I can let the jury go. Because if you can't speak with her tonight, that'll be a whole other issue.
Faith Brown...
Or depose her in the morning, one or the other.
Faith Brown has been watching the trial because she didn't know she wasn't subpoenaed and she didn't know she wasn't supposed to. So she has information about this court from other witnesses. She didn't do anything wrong. And apparently once she was notified that she was going to be a witness, she stopped, which was great. Emily Ahrens says, I really enjoyed Mr. Taylor's work on Schitt's Creek. He sounds exactly like the actor Eugene Levy to me. I've not watched that. I know it's a TV show. I thought Faith Brown was the judicial assistant. Some people are saying Faith Brown was the attorney that helped represented Ashley in the child custody case. She totally saw Murphy testify. Seriously.
Is she going to be available for you to speak with her this evening or tomorrow morning?
I spoke with her. We did not set up a time, but I think she will be available when I need to speak to her again.
Okay. All right. Great. So I'm going to tell the jury to be here tomorrow morning, 8:45, start at 9.
Sorry, Judge. I didn't realize you needed me to come back.
No, it's fine. Don't worry about it.
She was headed home?
Yes, bring him in.
There we go.
You will bring the jury.
Stacy, it's been a little bit messed up, but it's the technical shuffling that needed to take place for a new witness that's coming in to impeach a former witness, with the days they're taking off and the jury being here and who's here when. So it's just a logistical nightmare more than anything else. I think we've got it solved though. Listen for the knock. There's the knock. Jury's coming in. Ashley goes back into juror mode, or juror pose.
All right, y'all can have a seat. Welcome back, everybody. I know what you're thinking, that was longer than 15 minutes. Okay, so there are some things that we need to do on our end. And the reason I gave you that break was to have a conversation with the attorneys and kind of make a list of everything that we need to do before we can move on to the next step. So what I'm going to do is we're going to stay this evening and keep working, but I'm going to let you all go for the evening. So remember, please don't discuss amongst yourselves anything about the case or begin deliberations. Don't talk with anybody outside of the jury about the case. And please don't do any research on people, places, things, or legal topics you've heard anything about. Tomorrow, if I could have you downstairs in the jury assembly room at 8:45, and we're going to have a goal to start up here about 9 o'clock. Figure if we stay late and then some things tomorrow morning, we should be ready to get going then, okay?
Yes, sir. Okay, thank you.
All right, thank you. Just fold up your notes and leave them right there on your chair.
All right.
And we'll see you tomorrow.
All the jurors are like, good night, see ya, bye. Ta-ta. Cheers, love. Yep. They all say their goodbyes and head out.
Good night. Okay, y'all can have a seat. All right, the state having rested defense, your JOA.
Might be long. Buckle up, guys.
I have several bases upon which Ashley Benefield at this time, Your Honor, moves for a judgment of acquittal. To begin with, as the court knows, the information charges second-degree murder and requires proof that Ms. Benefield acted with a depraved mind. Furthermore, the evidence that exists at this point has raised a significant self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind. And number two, the state has failed to offer any evidence to overcome the self-defense claim that was raised as a result of the 9/11 call wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face.
That's the stronger argument.
So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield. What has been established is that Ashley Benefield feared Doug Benefield and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 9/11. And 9/11, of course, is what you do to summon help. And there has been nothing indicated otherwise that Ms. Benefield displayed indifference to human life.
That's where that testimony about how long he was dead, the body temperature might have been helpful for the
In particular,
state.
Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is "he attacked me and I shot him."
Is the judge read in his response right now?
There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield, and if they are properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden.
That argument should have been stronger. They must conclude.
The self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting.
Denouement.
Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintel, who said that, yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th. The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this. 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where is there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State.
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind, regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there is also spite or evil intent. And that is disjunctive, so it's or. And ill will is a very low threshold to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time, and she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said that this was the same exact judge that she had not had luck with before, and implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times. And the entrance wound of the fatal wound is not front. It is side to side. So he was turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor.
This argument's
so
wrong,
a lot of the things that defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA. Thank you.
Mr. Taylor, would you like to place any rebuttal in the record?
Very briefly. Thank you.
Or not briefly?
Yep, no, briefly.
Take your time, please. We've got all day.
Here's what we have, according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance as to what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick.
At the same time, you're shooting down.
I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed, and failed miserably to rebut it. thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right. Thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
No.
No.
Okay. All right. I just want to make sure. So, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by a preponderance of the evidence. I don't find support in the law for that. And I think that my findings from earlier are bolstered when you consider at the judgment of acquittal, I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think, based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal. You're going to see Ms. Brown.
No surprise there.
I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson. You're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it? I might be mixing apples and oranges. Something was 390 and something was
391 exhibits.
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing, and so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing, and based on that part missing, I will go back now and try to find it. So
What is it, a header or something?
yes, it was the top of an
The auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. But the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies or at least clue me into where it is and what exact pages are intended to be entered, and that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and then just to be safe.
Do you want to do it now?
Yes.
All right.
Here we go.
So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at a trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of the doubt that the testimony was wrong. So I think the court should factor that into the position we find ourselves, because I understand and I appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony. That can't be right either. So we have to find a happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. Well, I will tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
I didn't know about it.
I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said, on page 4, I have an envelope to seal this if necessary. I have Ms. Murphy's stand your ground testimony that I will pass to the court.
You might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking. That was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at the stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, were these turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about Vicky Mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Miss Murphy and Miss Brown as meaning different things? Could it be received by the jury to be substantial in their decision making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was documents, we could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules.
Richardson is a Florida case. That's why they talk
analysis
about Richardson.
Is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently. But I just, at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there is any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Faith Brown because she was not listed.
Yes. Okay. Do you want to be heard on that?
We just have a minute. We were just discussing.
Okay, so now we deal with Faith Brown. Similar issue. I think the judge will probably rule the same way. These are things that would not have come up unless, even though they were potentially foreseeable, they would not have come out in court unless the state's witness allegedly lied on the stand.
Judge, we've decided not to ask for a Richardson hearing on Ms. Brown. The state's concern was that, along with these emails, that it feels a lot like sandbagging to the state, or trial by ambush, as I think your judge, as Your Honor called it, and that was our concern. But in the light most favorable, in our mind, to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed or they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
Now that you've had it, and you don't have to respond, now that you've seen my order that has been unsealed, yes, I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So
he's not going to remind you.
I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing on calling of Ms. Brown.
Yes, yes.
Okay, cross that off your list, Judge. Just scribble it off. There you go. Scribble it off. Check your pen, make sure it works. There you go. It's working. What else is on the list, Judge?
So hold off on mechanic subpoena for now. The argument about it.
Yes.
Okay.
Mechanic.
I'm just going to put that on the back burner for now.
I suspect that's going to be resolved.
We still have a few minutes. I would like to, at a minimum, read my colloquy to Ms. Benefield regarding defendant testifying.
We've got 7 minutes before they close.
I typically will do this in a trial. I'll do it early on. I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
skip that
respectfully.
Fair enough. No, let me look. I don't think it does. All right, Ms. Benefield.
Stand up.
Listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions they'll be asking. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs. You understand what you're doing. You're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended, I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart, and I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney, and this is just piling the pressure on the client. I'm sorry, Your Honor, I find it uncomfortable.
You wouldn't be heard for the right. I mean, it's my decision.
I would like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say, and if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me. So if you say, hey, don't answer that, okay. But I'm going to have it on the record, because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify. My lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll ask, make sure that nobody's threatened you, forced you, or coerced you to make this decision, that nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it, and if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it, and then we'll have that conversation either tomorrow or next week. All right, anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law to support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response.
All right. Well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details, my answer was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course. Absolutely.
Maybe talk it over with the clients a little bit. This is a decision she has to say. She has a say in. They're going to decide if they want to proceed. Mr. O'Keefe, keep up, man. They're going to go into their little lawyer's room and discuss this briefly. See if she's cool with them having this discussion in public. with the state present, as it was an ex parte meeting before. Gut feel, they're going to drop it and not talk about it. That's my gut feel. They'd rather not have it in public. I can't figure out why we're still collating pages. 3 days into the trial, we're still stamping, stapling, shuffling, printing.
Judge White, we're good. Request withdrawn.
Withdrawn.
Okay.
I was right.
All right.
RA1.
Anything else we can talk about today? No?
What time are we starting tomorrow? 9, she said that.
Where'd my list go? Let's shoot for 8:45, just in case there's any last minute stuff.
Yes, sir.
And then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so.
Okay.
Right? We're going to have them lined up one after another, ready to go?
Pretty much.
Okay.
Back to back to back. What's the judge drumming on his microphone?
All right, we'll be off the record until tomorrow morning.
Thank you, Judge.
There we go. And we're off. Wow. And I missed the post office by 4.5 minutes. So they do not wait for anybody. So they're closed. I will go back. Maybe tomorrow during lunch we'll be able to go to the post office. Sorry, I think I ate a bug. All right. There was what they were deciding right there, Candy Kiss, was that the defense had approached the judge ex parte, meaning not during court, but like they had gone to him directly and said, "Judge, we'd like to talk to you about something that we feel should be discussed without the state present." That is an ex parte meeting. They X that party off. The state was not there. The judge looked at it, and there was a case. I'm not sure if it was case law or what was happening, because we didn't get the details. And judge looked at it and said, I think the state should be here for this. So if you want to go ahead with it, we want to have this discussion. It's going to be right here in front of the state, in front of everybody. And so they stepped out. Ashley was consulted. They made the decision together that they didn't want to proceed that way. They'd rather not bring it up publicly. So that's where we are. Now we're going to start tomorrow. There was a point today. When everyone's getting ready to leave. There was a point today when we were just going to have a work day tomorrow, as far as just the lawyers taking care of all the business. But now it's just a regular testimony day. The state has rested. Defense will begin their case tomorrow. We may have first thing that judicial assistant testifying about those emails that Miss Murphy got so stubborn about in her testimony. CBD, you laugh. I didn't think I'd have to list other people on there. My post office is strict, and I only put myself on there. I need to go revise this so my wife and maybe even my kids should be able to get the mail for me. But we'll see. Pull up Amber's message. Let me see where Amber's message is. Are we going to watch Sarah Boon hearing from this morning? It's absolutely 100% worth it. Let's see which one. Who has it, first of all? Where are we pulling from? Give me a second here. was the, let's see, Sarah Boon. See if we can find a copy that we are able to use here. Let's see. Let's bring this one up and hold tight 1 second. Where are you guys? Let's bring you over here so I can do this and that. Let's see if we can watch Sarah Boon's hearing. It's only 18 minutes long. It is short. So we can do that. We have time today before we end. Okay, here we go.
Mr. Cacciatore?
Dave Cacciatore on behalf of the state.
Ms. Boon, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, good morning. Could you state your name and date of birth for the record for me?
Sarah Boon, 10-10-77.
We also have a representative from Prison Break Investigations. Sir, if you could come forward, please.
This is Billy.
If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator for Prison Break.
Okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boon has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boon is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to coordinate the appropriate processes with the jail. In conversations with the jail, a laptop has been secured and will be issued to you after USB drives are provided with all the discovery. Upon the jail's receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boon. The laptop and USB device will be available daily to you, Ms. Boon, between 0800 and 1600 hours. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boon. The discovery was provided at the court previously and is in the two bankers boxes that are in front of the court to your left, Mr. Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through Prison Break Investigations, shall copy all of the discovery onto as many USB jump drives as necessary. The Judicial Administration Commission for the state of Florida shall be responsible for the fees and costs due to Prison Break Investigations for copying all of the discovery onto as many USB jump drives as necessary.
So he gets discovery.
You will appear for a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse with the discovery and all USB jump drives containing the discovery. A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, Prison Break Investigation shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation. Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
supposed to be out of state from Tuesday until Friday of next week, which I believe would encompass August 1st for my son's wedding.
Okay, well, congratulations. When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay, will you be able to complete that task by that time?
Yes, sir, I'll do my best.
Okay, sir, we will see you on give me a second, I want to make sure I get the date right. Monday, August 5 at 8:45. Okay, you'll be given a copy of the order that I just read from. Ms. Boon, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused. Was a notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, you're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him, so he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work. And I understand that your case is important, and I want to move as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space, you have almost no privacy, you have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants and
the judge is probably right here, Sarah.
I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail. I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay.
If only you had a lawyer.
I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right. Okay, so I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies. So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
Will I be having additional time added, or will it be extended from the time period of me waiting for my
She's
discovery
asking for a
still?
continuance.
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared, and obviously I do not know what I'm doing, and obviously I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just miss a month.
The dates are what the dates are.
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
Okay. 5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your
you hired him
investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can?
Mr. Lane, who contacted you in order for you to be here, please?
The JA contacted me.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right, which
It
is
makes
now
things
formed.
exceptionally more difficult, as I explained to you, in communicating with the court and communicating with the state attorney's office.
Wow.
Isn't that what a certificate of service is for anything that's filed by anybody in the court?
There
I
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set. It was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as and perform as?
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
How is it the news knows before I do?
You keep asking the same question, and the answer is going to be the same. I cannot answer that question for you because I do not know.
Okay.
The news
But
has
you
access
do
to
know
a
it's
computer.
harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am, if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to, and it took time for a process to be created by the Orange County Jail. As they had advised me, they do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know what to say, and because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did, but I don't know going forward how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me. Is that what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them, and if we have to set a hearing, you'll be properly noticed for it.
In the certificate of service.
You'll be properly noticed for it, yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Am I allowed to ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
They drove, Sarah, because they don't live here.
It's wrong and it's unfair.
You certainly entitled to that opinion.
Am I allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I will be happy to do that. It is the policy of the Orange County Jail to have a letter represented from an attorney to allow me to access you. That's the reason for the past previous couple of attorneys I've not had the ability to come out and access you, but that's changed. And I will be happy to continue to move forward with any investigative actions I can do for your defense. As long as that's
She's going to have a million questions that
So you need a letter from me?
or the judge or the jail, somebody that will allow me access to you. Yes, ma'am.
And I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything.
But you all are the ones who contacted him.
But I can't tell the jail, let this person come talk to you. If they have a policy where you need to provide the letter, then you need to provide the letter.
So until you have that letter, you and I will not be able to speak with one another?
I will contact the jail myself and find out if there's an exemption for pro se, or maybe they can speak to you directly to circumvent the actual letter itself.
Thank you.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
I will be on.
If you could please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right, thank you all very much. Mr. Cacciatore, anything further, sir?
Nothing from the state.
All right, thank you very much.
Thank you, Your Honor.
Thank you, sir. Have a great day. Oh, wait, before you leave, that is all going to be yours. Yes, I
All
would, sir,
these
so that you can
boxes
begin the
belong to you.
digitization process. All right, I'll see you on the 5th.
I'll have you return your
Perfect. Thank you, sir. Yes. I'm just...
She's not happy.
Yes. Sir, can you just hang out for a second so I can give you a copy of the order? Appreciate you. Thank you.
Is this a reporter? Why are they stopping the processing to have her have this discussion? I don't think this is a court officer. Maybe it is. Yeah, she is. She's not happy she got the 3 a.m. wake-up call for court. Surprise! Maybe she's interviewing a lawyer right here. We're catching the whole thing happening here. Okay, I don't know what I'm supposed to do. Don't know what I'm doing. There we go. All right, that was it. That was it. Wow. We knew what had happened, but watching it happen in real life play out, this is what I think this is. This is going to be how the court operates or how things proceed during this trial. It's going to be off the rails throughout this trial. It's a short trial. It's only going to last a couple days, probably less than a week. The lady works for the prosecution. Okay, so they're trying to figure some things out. Oh, my goodness. Oh, wow. More letters incoming. 5 motions to be filed. They're all going to be eventually listed in the dockets. We'll bring those to you as well. They're probably going to be handwritten motions, as she doesn't have access to something to print on. Thank you, Amber, for the reminder that happened. Yeah. Whoa. What a way to end our day. With we're about to begin in Ashley Benefield trial. We're about to begin the state's witnesses tomorrow morning. We've had some spicy argument, lots of bickering back and forth between the lawyers. We think we've sorted out all the technical details and the complaints. I think we're ready to move forward again tomorrow with the defense's case in chief now that the prosecution is rested. JOA denied. So we're gonna move ahead with that. Never a dull moment in the world of true crime. That's just... Wow, that is crazy. Sarah Boon is pro se. That's the last part we just saw. She's pro se. She just found out that the investigator she hired on her own, or reached out to her on her own, still listed on the case, getting paid for by the state, is getting a copy of the discovery. He's going to facilitate her getting a digital copy. The court has ordered, and that worked out with the jail, that she will get a laptop to have during the day, no charger cord. So as long as the battery lasts, she'll have a laptop to review her items, her discovery, prepare her case that way. It would only be during daylight hours. And that's it. Yes, podcast tonight, 8 p.m. tonight on this channel, which is soon. It's only like 3 hours from now we have a podcast. So if you're not doing anything tonight, or even if you are and you would like a little distraction, please go ahead, click the subscribe button, ring the bell, and then when we go live tonight, Thomas and I will be bringing you the best of everything that is not relevant to the world of true crime, and sometimes a little it is. Bring your popcorn as well. It's going to be a lot of fun. So, no, she gets the charging cable. No, Dodie. The charging cable will never enter there. The charging cable's kept in the control room, but it will be charged overnight, so she'll have it during the day. The charging cable is a security risk because you can wrap that around somebody's fingers. Anyway, this made up for the boring day, says Nosy Rosie. All right, thank you, everybody. Thanks for being here tonight. When you go home, please hug the people you love. I said talk to somebody. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again tonight at 8 p.m. for the podcast, the Not Relevant Podcast, 8 p.m. Eastern Time. You guys be good to each other. We'll see you shortly. All right? How about that? Shortly works. First try.
You're talking about stuff that is not relevant.
If they didn't, I would lose my mind.
Because he's the guy.
I think I'm about to catch a whooping.
Shame on you, sir.